usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found
All rise, the Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Good morning. Please be seated. We're here at the time set for oral argument in file number 2026-0095, Rodney Harold Friesz versus the State of North Dakota. Sitting this morning are Justices Jared Tufte, John Jensen, Douglas Barr, and Mark Friesz. I am Lisa Fair-McEvers. And appearing for the appellant this morning is Attorney Kara Krauspar, and for the state, Mr. Chase Lingle. So, Ms. Krauspar, you may proceed when you're ready.
Morning, Chief Justice, Justices, Counsel. May it please the Court, I'm here representing Mr. Friesz on this denial or summary denial of his post-conviction relief petition. The main issue was new evidence, so he has several identified issues, but I think that the main argument or problem was that he's outside of his 2-year time frame, although I would point the Court to the order granting the summary dismissal. That's record at 38. In paragraph 6, the Court identifies the reasons that they're summarily dismissing the petition. They identify 3 reasons: 1, res judicata; 2, misuse of process; and 3, that there's no newly discovered evidence. And then the rest of the order goes on to discuss why the Court has ruled that way. I think the res judicata and misuse of process fold into the new evidence, because if it's new, then if it's new as defined under the test, there's no way he could have brought it. So misuse of process is out. And then also res judicata is out, because if it's new, he wouldn't known about it, and no recent, or the recent discovery would essentially take out those 2 reasons. And so then we're at, was it newly discovered evidence or wasn't it? In the state's brief, they pretty solidly say there's nothing supporting the claim that there's newly discovered evidence that would get him outside the 2-year time frame. And in my brief, I specifically, because that was addressed in the Court's order, and in my brief I explicitly say, well, his petition, which is a verified, treated like an affidavit, does support it. He identifies that Chris Barrett has made an updated confession, meaning that this is a new new information has been added that would have affected the outcome of his trial, specifically that he's admitting to robbery. And in the proceeding, the underlying criminal proceeding, his statements were that he would never killed anyone. He didn't set the fire, that there was a robbery that occurred at the time. So these are all, excuse me, from the record, the underlying record and the post-conviction record, part of the petition. The Court finds that this is not, that he needed to supplement his petition with more information, potentially from Mr. Barrett. But the problem there is, if he's a non-cooperating witness, you're not going to get a voluntary affidavit from him. You're going to have to subpoena him, and the evidentiary hearing would be a place to do that. This is summary dismissal. This is just, is there enough information to move forward to have a hearing on the merits of this new information that would then affect his, essentially affect his case, the outcome of his case, because that's the last.
Did the petition say how your client was aware of this new?
How he came to be aware of it?
Yeah, how he came to be aware of this alleged confession by this other person who you're saying is uncooperative?
Well, I would say I don't take a position because the record is silent, so I want to be clear. But I'm just saying that the Court appears in their order to be saying that he should have gathered some sort of affidavit from this individual. But
well, isn't his allegation in his petition merely that, an allegation that someone else confessed without it? Isn't that conclusory by itself? I understand it's a sworn declaration or under penalty of perjury, but without more information about it, how
you're
can
supposed to
that
give
stand?
him all the inferences that can be drawn from that. And so he's saying, At the time, I said that this was a robbery, that I didn't do this, and there was a robbery that was occurring. And then in his petition, the murder was a result of those robbery, and the fire was to cover up that crime. It wasn't me. That's essentially what he was arguing below. And I think he brought it up, and that goes to the res judicata, right? That he's brought that up before. The issue is that he's then put into this petition, hey, there's an individual that says, that they gave more information about a robbery at this, and for that to be a light in most favorable to the non-moving party, so to my client, you'd have to infer that this is
So who heard this confession?
It was, I don't know. This is basically what, I can't give you the information from the record.
Well, he's not saying he heard it, because if he heard it, it would be hearsay, right?
Right, but if you subpoena the individual and ask him questions, then
No,
you.
but maybe he confessed to someone who that's my question is,
Right.
him just saying, so-and-so confessed all by itself, without saying, confess to me, confess to somebody else that I can identify, isn't it merely a conclusory allegation? I'm back to my first question. It's just, I can say whatever I want to say in an affidavit, and that doesn't mean it's reasonable to give an inference to that person without more information.
I understand what you're saying, but then you're reading inferences away from the non-moving party. You're saying that this isn't supported, that this is not true, essentially. Because what is hearsay other than you're saying that we don't know if it's credible because it's secondhand information. So I don't know that we get around the standard of giving the inferences to the non-moving party by saying that something is hearsay. It's problematic. I understand that there's a case that when we get down to the fourth prong element, however we're going to say, of the newly discovered evidence test under post-convictions explicitly, that it has to be something that will affect the outcome of the trial.
Well, it's even more than that would affect the outcome of the trial. It has to show that hasn't committed the crime, I think.
Yeah, you're right, yes.
There's a difference.
Yes, so under 33, it would affect the trial. Under post-conviction,
Right.
he didn't do it, which he alleges in his petition.
Under post-conviction, past the 2 years, that's the test.
Right, because it's newly discovered evidence, generally you see it for DNA, which he also, and I do briefly discuss it in my brief, and I don't recall if the state responded specifically to that, but he does allege there's testable evidence in where he's receiving that evidence, where he's receiving the information that there's testable DNA, that there's now an ability to test the DNA evidence. Again, in the light most favorable to him, you would assume that DNA would, again, exonerate him, and you would need testing done. And that's more of a discovery process issue. So you would need to contact a lab, try and collect the DNA, go through the discovery process.
Do our cases support inferences that far, though? Because I'm reminded of some arguments you've made where we have a missing witness,
Right.
and we have no assertions of what that witness would have testified to or why it would have mattered to the jury. This feels like you're building a lot of inferences on updated confessions.
Sure, but he specifically identifies robbery, and in the context of it's not like we don't know what it's about that he's alleging this witness is going to speak on. He's saying that the witness is going to talk about a robbery. I was alleging, and this is kind of where the res judicata comes in as well, is that he said that this was a robbery gone wrong and not me. But now he's saying there's more information, and I think even the court in its order talks about, well, previously he identified somebody else as the robbers in this scenario. And so again, the inference is then, okay, well, he's got new information about who was present during the robbery, what the robbery does. So it's a little bit different than what you're asking.
It seems like it's asking for more inferences than we've usually allowed, though. It says updated confession. It doesn't say he said he did it and I wasn't there, or anything that would sort of be exculpatory in that way.
You have a point. I mean, I can't the record is what it is. This is what he has said. But I just think that you have to look at the context of the underlying criminal case, what he's maintained, what he's put into his petition. It's not just the petition standing alone. The fact that they are arguing res judicata on this issue, which means they are at least aware of what his previous issue has been and that it's been litigated, and he's saying, well, now I have this new information. It's a little bit different here if you're saying, some guy said I didn't do it. I think that those are different sort of statements. It's one clearly has some sort of path, evidentiary path forward, which would be this, whereas the other is just, there was a neighbor who said I didn't do it. Even that, you would need some more, I think, information of who this was, why they would have been there, et cetera. This, I think, because he's claiming that, in the context of the prior claims, he's claiming that this guy admitted to robbery, and it's updated, and so he didn't have access to it previously, which goes to the misuse of process.
Wasn't it to an unrelated robbery? Somehow, I have in my notes that he,
Well, it's
let's
not
say,
clear.
updated confession to unrelated robbery.
I don't think that I think that's where we're having the discussion is, I don't think that it's clear from what he stated what robbery. So he neither says it's unrelated, nor does he say that it is related. It is blank, and I think that was Justice Tufte's question, and Justice McEver's question, is that wouldn't we need more of a connection to the robbery that he's alleging occurred?
And isn't that really the whole deal? The district court needs more information too, and once there's an application made by the state for summary disposition, that notified your client that he has to do more than just make an allegation.
This goes back to my evidentiary problem with if you don't have someone who wants to cooperate with you, you're going to need to.
Then you get an investigator and you do what you can. You identify that they're not cooperative. The standard that this court has pronounced is there has to be sufficient, competent, admissible evidence.
Yeah.
It doesn't have to come from the person who's going to be deposed. An investigator attempting to get it could have filed an affidavit as well.
That would also be hearsay. I mean, is that admissible evidence? You wouldn't have the investigator get on the stand and say.
So the answer is provide nothing to the district court?
No, I concede that there is gaps, and so there would be, what I'm saying is I don't think this is quite as far as Justice Tufte was pointing out, that there's no inference that he's just making a statement. So I think there is a logical line that you can follow. It's kind of up to this court if that's too far. It's too much of an inference. That's really what we're here on, is whether or not the district court was correct and couldn't give him that much leeway, or if there was leeway to be, or if there is a clear logical line through of the evidence that he's alleging based on his underlying case and what he's put in his petition. I think that my main point about the state's brief and the district court's order is that neither one of them seem to, well, I don't know with the district court because that's not really clear from the way the order is written, but I will say the appellee's brief doesn't seem to track like Davies v. State, which is that we do use the petition as an affidavit, as evidence in support of the petition. They don't have to put any facts in there. The claim could have just merely been newly discovered evidence, and then they would have made their summary judgment motion, and then he could have responded with all the facts that he already had in his petition. And then we would be here arguing the same thing, is that's sufficient facts to go through that test. Which I think there was enough facts if you're looking at it in the light most favorable to the non-moving party. And so I do believe that the district court was in error and they should be reversed so that he can have his evidentiary hearing. Thank you.
Mr. Lingle, whenever you're ready.
Thank you. Madam Chief Justice, Justices of the Supreme Court, Counsel. As indicated already, this appeal primarily revolves around a single issue, whether the district court erred in summarily disposing of the post-conviction proceeding. That issue involves one major assessment, which is whether Mr. Friesz supported his application with competent admissible evidence once put to his minimal burden. The state's position is that the record is clear that he did not. As made clear by this court in Mr. Friesz's previous cases, once the state moves for summary disposal, the petitioner is put to his proof and must support it by some competent admissible evidence. What that competent admissible evidence is, or other, is indicated as either an affidavit or other similar evidence. What this court has made clear in Oud v. State is that they can't merely rely on the pleadings or on unsupported conclusory allegations, which is exactly what the appellant here is asking this court to do, is to say that he could rely on his pleading and or on the unsupported conclusory allegations contained within. State's not here saying he needed to have Mr. Barrett sign an affidavit outlining the exact confession. Even something from Mr. Friesz himself in affidavit format outlining what the nature of the confession that he heard was, how he came to know that information, when he came to know that information, how that information relates to it would have been sufficient, competent, potentially admissible evidence to support it. In the same way that when the state files an affidavit in support of charging documents, that affidavit can rely on hearsay information told to the law enforcement officer. That hearsay statement eventually, as long as we have that witness there, becomes testimony, which is competent admissible evidence at that time. So in this instance, Mr. Friesz failed to provide any clarifying information about what the nature of this confession was, other than that there's a confession to a robbery by Mr. Barrett. What that robbery is, when that robbery happened, how that robbery directly relates to this, unclear. I will grant that at that stage, the court does have to make all reasonable inferences on behalf of the non-moving party. However, if the court's not provided with facts regarding that, the most in this case that the court could make reasonable inference of is that the robbery somehow related to the events that led to the death in this case. As pointed out in the state's brief with regards to the DNA evidence, there's no indication how that differs from the DNA evidence previously raised in post-conviction cases, in his post-conviction relief cases, which were also summarily dismissed, which were also brought forth on appeal as well. None of that was followed up on in reply to the state's brief. The only issue that remained to be addressed within that was the ineffective assistance of counsel claim, which, without newly discovered evidence, does not survive a timeliness concern, does not survive a res judicata concern either. If the ineffective assistance of counsel claim is that Mr. Friesz brought this to his counsel previously in the prior post-conviction, then perhaps it could have, but there's no indication as to what the nature of that claim was either, other than that he received generic ineffective assistance of counsel. So, at this point, the record is unclear as to what this confession was. It's unsupported as to whether this was in fact newly discovered. There's an inference that can be made that arguably it was, but it's unsupported once he's put to his proof. So, the concerns about not having a cooperative witness in Christopher Barrett is negated by the fact, as has been pointed out, that it didn't need to come from the individual who made this alleged updated confession. It could have come from Mr. Friesz. It could have come from an investigator. It could have come from another individual who had overheard what Mr. Barrett's alleged updated confession was, which then is used to support, okay, no, there is enough evidence here at this time to allow it to go forward. I guess there is some question as to at what stage the prior phrasing of competent admissible evidence is. In motions practice, hearsay is admissible, so I would argue that when the court is referring to competent admissible evidence, it's pointing to competent admissible evidence to support the motion hearing, which then gets to the evidentiary hearing portion. And at that point, he would have to support it with additional non-hearsay competent admissible evidence.
Mr. Lingle, with respect to the timing of when these things are triggered, What is your position with respect to the inferences that can be drawn? Does the district court draw inferences from the evidence after the petitioner responds to the state's application for summary disposition, or does the district court go all the way back and draw inferences from the petition itself?
Justice Friesz, the phrasing for the drawing of reasonable inferences indicates that, though, if I recall correctly, indicates that those are to be drawn from all of the evidence, the prior pleadings, any discovery that's part of the record, anything that is on the record, which triggers once the state puts the petitioner to their minimal burden of proof.
And then
So
what's your
upon
response? What's your response to Mr. Friesz's argument that the petition itself was sufficient when inferences are drawn from it to entitle him to further hearing?
As this court has already indicated in Oud v. State, it's made clear in that precedent that you can't just rely on the petition or on the pleadings. The petition in this case is a pleading. It's the pleading that starts the whole post-conviction process.
It's sworn document under penalty of perjury, so we do allow that to be relied on if it is done in that manner, isn't that correct?
That is correct. My understanding, however, of this court's decision in Oud v. State is that
Could you tell me that, what's the case that you're talking about?
I'm probably mispronouncing it, UDE.
Oh, okay, I
State.
wasn't quite
I'm
catching
not sure
it.
if it's Oud or Ude or.
Okay, I got it, I understand what case you're talking about now.
So in that case, my understanding is that the court there was referring to both the application for post-conviction relief as well as the state's briefing, or the state's answer, not the state's briefing, but the state's answer to it as being potentially the pleadings.
Mr. Lingo, I have a question on the amended petition. There's, at the end it says, see attached documents enclosed. And the number one is Chris Barrett's confession to the robbery. I did not find that purported attached document. Did I just miss it, or was there something that's supposed to be his confession?
It's unclear. I noticed that too when this was first filed with our office and our office first received the mailing on it. Nothing appears in the court site. It doesn't appear that the court got anything, and our office didn't receive anything either. I'm not sure if that was if this was drafted before the form petition, or if it was drafted following the completion of the form petition and then slid in there.
Well, and it refers to attached documents, but it appears to be more a summary of the arguments rather than referencing documents.
Correct. And if there were documents that would have or could have been attached, those could have also been raised in reply to the state's response when the defendant, or when the petitioner was put to their motion, or put to their proof on this.
My recollection, and I could be wrong, is that Oud, if that's how you pronounce it, I don't know how to pronounce it either. The Oud case was likely before we added to our form a place to add under penalty of perjury. And it used to be, from my recollection, that sometimes folks who were filing these applications would somehow get them notarized or say they're sworn and subscribed or those kinds of things. And since that, I think it's been since that case that we added to the form the section where they could just sign it under penalty of perjury. So I have to take a closer look at that case to see if what you're arguing here is something different based on the form that they used to apply under. My question for you, though, now is if we agree with you that the newly discovered evidence doesn't meet the test for the statute of limitations, do we even have to address the court's other reliance on res judicata and misuse of process? Do we even have to look at those?
I would argue no. My understanding of the court's order was primarily that he failed to support this claim, but also even if he had, there's, based on even if we are taking all of his inferences, all reasonable inferences drawn from it, there's still no indication how it differs from the previously raised claim from Mr. Bonakovsky.
If we don't say that there isn't any new evidence, how can res judicata apply if it is truly newly discovered evidence that meets the test?
So that gets complicated because, again, we don't know what the nature of that confession was. We don't know, as pointed out by the district court, how that differs from the previous claimed confession related to, I believe it's Bonagovsky, related to a robbery that occurred on this date,
I think
which was
he
also
did
unsupported.
say in his application that he couldn't have found this sooner because it is a new confession.
He indicates updated, which also doesn't necessarily, I grant that reasonable inference there is that it was discovered recently, drawing that on behalf of him. However, again, it's still not clear what the nature of that is. So even if it is a new confession, is there any difference to the prior confessions that he has received? If that prior confession by Bonagovsky that he'd previously raised in prior post-convictions had, for example, outlined the names of participants, including Christopher Barrett, would that then be newly discovered when he could have discovered it at some point in the past by virtue of digging into Mr. Bonagovsky's alleged confession? And where does that fall? So part of this entire case seems to fall back on the lack of support and lack of clarification from Mr. Friesz when put to his burden. I will note with regards to the Ood case that was decided in 2009, the form petition submitted indicates that it was revised June 2024. So,
And I think that addition to the form has been there longer than 2024, but anyway, I just know that there was a change in how we allowed folks to make their initial applications to be a sworn statement of some variety.
and as pointed out in the state's brief, there was the prior statements made by Mr. Friesz in prior post-conviction relief cases that are wholly unsupported by the facts. The claim with regards to DNA evidence, for example, that an individual out at the state pen told him that there was evidence from held
Seems
by the
like
Morton County Sheriff's.
you're saying the court was weighing his credibility on this application.
It's unclear. I'm saying the court could have.
Should the court weigh credibility at this stage?
If he's raising concerns with regards to prior potentially perjurous statements, the court is allowed to make some inference as to with regards to drawing inferences, whether to fully draw them or whether they can still be called into question. Same with a law enforcement officer. If a law enforcement officer, for some reason, remains a law enforcement officer following a proven perjury, Giglio and Brady trigger, and can be called into question whether the court is going to fully rely on that statement, for example, at a preliminary hearing. So the court, in determining inferences, can weigh whether or not the source of that information has provided false information, demonstrably false information.
This falls under our Rule 56 standard, right? Genuine issue of material fact, this is the stage.
Correct.
So don't we specifically say the court is not to weigh credibility on those?
I'd have to double check the phrasing of it, but if you're indicating that it says that, I have no reason to doubt you. So, again, state's position is that this falls to an unsupported conclusory allegation once he was put to his burden of proof. State's position is that the district court correctly determined that this case did not present a genuine issue of material fact and therefore was appropriate for summary disposition. State would ask this court to uphold the district court's ruling. Thank you.
Thank you, Mr. Lingle. Ms. Crosspar, you have 5 minutes in rebuttal.
Just wanted to address the Ood case, I guess, and the state's contention that you can't rely on the pleadings. Again, I think that that is incorrect based on Davies v. State, which is a 2018 case. Ood came out, as the state suggested, in 2009. Ood came out before there was even a statute of limitations in place, so, which the post-conviction relief chapter was changed in 2013 to the 2 years, but putting in a statute of limitation, putting in the 2-year time frame. And then also Chase came out in 2021, overruling Delvo, which made all the civil rules of procedure apply to post-conviction cases, or that the court should be using the civil rules of procedure. So I think that the reliance on Ood is incorrect here in this context. And my previous argument is essentially his claim, if we're narrowing the claims down, because I think that the state is correct that really without the new evidence, you can't get past the statute of limitations. But if we're narrowing his claim down to that, that's the claim, that's the pleading, is that there's newly discovered evidence that proves actual innocence, because that's what's necessary for post-conviction, newly discovered evidence. And then we have facts supporting that based on his petition, and that's what the Davies case is about. And I think it's, he has it in 2 different places. So in the form part of the petition, on page 3 of 8, he says the petition I think he means petitioner, but the petition alleges the existence of newly discovered evidence, including DNA evidence, which proved and reviewed in light of the evidence as a whole, would establish that the petitioner did not engage in the criminal conduct. And then there was also the updated confession, which is on page 5 of the form.
And then he says, see attached, and there's no confession attached.
I looked and I tried to discover what that was, but I could not discover. There was nothing in the record. So, but there is the attached additional information. That's the pages 7, 8, and 9, where he does talk about a little more information about what he's alleging. The confession to the robbery was at his brother's house, or at the house where he was staying, and then that he's maintained all along that he wasn't the one that killed the woman, and that he did not set the fire, and this was always about a robbery. And so that's where I'm saying the inferences lie. In his straight out in his petition, he's arguing that. And then the underlying criminal case, his other allegations, there is a follow-through line where he's alleging this person made an updated confession that I just found out about because it's newly discovered, and it shows that I didn't do this, that this was somebody else. So he's hit all the steps. It's whether or not that's enough of those are enough to raise the inference in his favor, to have an evidentiary hearing where he can actually call witnesses to support his petition. And I think that this was sufficient, and that the court should reverse the district court. Thank you.
Thank you, Ms. Krausbauer, for your arguments this morning, and Mr. Lingle for yours as well. This case will be taken under advisement, as all cases are, and court is adjourned until 1:30 p.m.